The next segment, segment 4, addresses procedures related to competency and competency restoration. A significant part of the focus of our discussion is going to be on the distinction between defendants who are charged with Class B misdemeanors and those who are charged with offenses at a higher level, Class A misdemeanors or higher level. The purpose of making this distinction is to address the circumstance that was identified in the course of inquiry into the effectiveness of how the criminal justice system is addressing the needs of defendants with mental illness. A recurring issue has been identified, which is the fact that the number of available beds in state psychiatric hospitals is not sufficient to meet the need. Those beds serve a number of different purposes. One of those purposes is to provide a resource so that defendants with mental illness, if they are incompetent to stand trial, can receive appropriate medical treatment in order to restore rational thought so that they can proceed with their case in the criminal justice system. But because of the fact that the demand statewide exceeds the supply of beds, a circumstance has arisen where defendants who are charged with Class B misdemeanors, who face a maximum of a 180-day sentence, may be in a situation where they are bumping up against the limits of the sentence for the offense that has been charged because they can't get the competency restoration services necessary to have the criminal process move forward. To address this circumstance, the revisions to Article 46B authorize and contemplate the creation of local, community, or jail-based competency restoration resources so that a state psychiatric hospital bed is not the only resource available for a criminal defendant charged with a Class B misdemeanor who needs mental health treatment in order to have competency restored. We're going to unpack the particulars of that in a moment, but that is the overview to bear in mind about why the distinction is being made in these amendments between Class B misdemeanors and those who are charged with an offense, Class A misdemeanor or higher. Another point to bear in mind, and another point that is underlying the rationale behind these changes, is that competency restoration really has two components. One component is medical treatment in order to restore rational thought for a defendant who is mentally ill and determined to be incompetent. But once the process of rational thought has been restored, there's also additional education that has to occur so that a criminal defendant has a basic understanding of rights and the process that will be going forward as the case proceeds through the criminal justice system. As we will see in going through some of these specific statutory amendments, the focus has been on recognizing that there may well be circumstances where the medical component of competency restoration can be provided in one setting and the individual educational component can be provided in another setting. Another key fact to bear in mind when we talk about changes to competency restoration procedures is that the statutory changes we're talking about are contemplated to expand a jail-based competency restoration option. This option already exists to a limited extent in some locations, but the goal is to provide both an authorization to use it in the statute and a mechanism to create this option so that it can become more widely available. It may be state funded or county funded, and we'll talk about the funding sources a little bit later in the presentation. Guidelines and rules for these types of facilities and procedures are also being developed concurrently, so that the option will not only be statutorily authorized, but will also be, on a practical level, available on a local basis. An important point to remember is that the jail-based option will be available for use only if the defendant can begin to receive competency restoration services within 72 hours of arriving at the program. This is a provision under 46B.073. Again, the point is to promote the creation of local treatment options, but there's also recognition that those options have to be up and running in order to be effectively used. The creation of jail-based competency restoration is really going to be governed by Article 46B.091, which is going to govern the county implementation of these programs. And the basic mechanism that has been created is one under which a county will contract with the local mental or behavioral health authority to provide these services. So let's return to the distinction that I mentioned a little while ago about Class B misdemeanors versus defendants who are charged with a Class A misdemeanor or a higher level of offense. With respect to a Class A misdemeanor, a defendant who is charged with this level of offense is going to be committed to a mental health facility or jail-based competency restoration program under Article 46B.073, or the court shall release the defendant on bail to an outpatient competency restoration program under Article 46B.072 using existing procedures. The significant changes really focus on Class B misdemeanors. So if a defendant is charged with a Class B misdemeanor, the court shall release the defendant on bail to outpatient competency restoration under new Article 46B.0711, or commit the defendant to a jail-based competency restoration program under Article 46B.073E, or commit the defendant to a mental health facility or residential care facility under Article 46B.073F. This latter option under Article 46B.073F will come into play only if a jail-based competency restoration program is not yet available, or if a licensed or qualified mental health professional determines that a jail-based program is not appropriate in a particular case. For a defendant who is subject to restoration under Article 46B.071, the court shall order release on bail and participation in outpatient competency restoration for up to 60 days under certain circumstances. The release is subject to conditions reasonably related to ensuring public safety and the effectiveness of the defendant's treatment. The court must determine that the Class B misdemeanor found incompetent to stand trial is not a danger to others and may be treated safely on an outpatient basis towards the goal of obtaining competency to stand trial. And appropriate outpatient competency restoration program must be available. The court must receive and approve a comprehensive plan that provides for restoration treatment and identifies who or which entity will provide that treatment. The court must find that the proposed treatment will be available to and will be provided to the defendant. And the court may require the defendant to participate in outpatient competency restoration and an appropriate prescribed regimen of medical, psychiatric, or psychological care or treatment. We talked a moment ago about the distinction between restoration in a medical sense versus the educational sense. The changes under 46B.079, .0805, and .0825 focus on the education component. When a defendant is clinically ready to be transferred for competency education services, but is not yet competent to stand trial, the head of the facility that is conducting the medical component of the treatment will notify the court. Once notified, the court shall order the defendant to receive competency education services in a jail-based or outpatient program, again, if appropriate and if available. And during that period, the sheriff is required to maintain medications while the defendant is in custody unless funds are not available from the state for that purpose. An additional concern that was identified leading up to the legislative session is that delays related to competency restoration sometimes occur after the restoration has occurred. So it's not just waiting for an appropriate treatment availability to become open. After competency has been restored, there can be additional delays on the back end when a defendant has been returned to a trial court, but because of the delays related to competency restoration, has been bumped from the docket or put to the end of the docket, so that additional delays result even after the defendant is competent to stand trial. And in light of this, the statute provides in Article 46B.084 that the action of a criminal defendant who has been restored to competency will be given preference over other matters of the court. Courts will be required to submit monthly reports to OCA outlining the receipt of competency restoration services.